While there's no doubt that in India, marriage is an important social institution, but the concept of a live-in relationship is fast emerging as more and more people are shying away from the institution of marriage. There is also no doubt that the concept of live-in relationship is not acceptable to all. But such a relationship cannot be said to be an illegal one, or that living together without the sanctity of marriage constitutes an offense. It is interesting to note that the word wife has not been used under the Protection of Women and Domestic Violence Act 2005. Thus, the female live-in partner and the children of live-in couple have been accorded adequate protection by the Parliament. Even under the said act, a woman who is in a domestic relationship has been provided protection. So, domestic relationship has been defined under Section 2F of Protection of Women from Domestic Violence Act as a relationship between two persons who live or have lived at any point of time. Any point of time. This has been discussed in various case laws, any point of time in a shared household when they are related in consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or other family members living. That is besides the point. Now, relationship in the nature of marriage is akin to a common law marriage, which inter alia requires that the parties must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. The parties must also have shared household as defined in Section 2S of the Act. It has to be taken into consideration that merely spending weekends or one night together does not constitute a domestic relationship under Section 2F, and not all live-in relationships form a relationship in the nature of marriage, because several parameters have to be satisfied in order to constitute a relationship in the nature of marriage. Now, the personal liberty of an adult woman has been protected by courts since long. And in case titled Gyan Devi versus the Superintendent, Nari Niketan, Delhi, that's 1976, Volume 3, SCC 234, the Honorable Apex Court had held that a woman who had crossed 18 years of age is sui juris, and no fetters could be placed upon her choice of person with whom she wanted to stay, nor any restrictions could be imposed regarding the place where she should stay. Now, this was in 1976. It needs no special emphasis to state that attaining the age of majority in an individual's life has its own significance, and the individual is entitled to make his or her choice. In Shafeen Jahan versus Asokan KM, that is 2018, Volume 16, SCC 368, it was observed that the expression of choice is a fundamental right under Articles 19 and 21 of the Constitution, if the said choice does not transgress any valid legal framework. It was further observed that once that aspect is clear, the inquiry and determination have come to an end. Lata Singh versus State of Uttar Pradesh and another, 2006, Volume 5, SCC 475, is a landmark judgment that has discussed the validity of intercaste marriages. Here it was observed from the it can be observed from the court's decision that any person who is a major has a right to choose the partner of the choice or live with anyone they like. Shakti Vahini versus Union of India, 2018, Volume 5, RCR, Criminal 981. Here, the Honorable Supreme Court has held that right to exercise assertion of choice is an insegregable facet of liberty and dignity. The concept of freedom of choice and live-in relationship were again discussed in detail by the Honorable Apex Court in case titled Nanda Kumar and another versus State of Kerala and others. That is 2018, Volume 16, SCC 602. Here it was observed that live-in relationship was recognized by the legislature itself under the provisions of the Protection of Women from Domestic Violence Act. Thus, once an individual who is a major has chosen his or her partner, it is not for any other person, be it family member, to object and cause a hindrance to their peaceful existence. No doubt the social values and morals have their space, but they are not above the constitutionally guaranteed freedom. The principle that no one shall be deprived of his life or liberty without the authority of law is rooted in the consideration that life and liberty are priceless possessions, which cannot be meddled with on individual whims and caprices, and that any act which tampers with life and liberty must rest on sanction of the law of land. The concept of providing protection to runaway couples. I mean, this is just a passing reference to the runaway couples because we all are going to be session judges soon and we are going to provide this protection to them. Has been discussed in detail by Honorable Punjab and Haryana High Court in case titled Sonia and another versus State of Haryana and others, 2021 SCC Online, Punjab and Haryana 987, where it was held that when the parties who were major and had taken a decision to reside together without the sanctity of marriage, it was not for the courts to judge them on their decision. Accordingly, necessary directions were issued to the concerned authority for providing protection from any threat to their life and liberty. However, it was made clear that the order did not provide protection to the parties from any legal consequences. There was another case, Kulbir Kaur and another versus State of Punjab and others, bearing number CRWP 5949 of 2021, which was decided on 1st July 2021, wherein the Honorable Punjab and Haryana High Court, while providing protection to the life and liberty of the runaway couple, directed the minor petitioner to be kept in a safe house and also gave liberty to respondents number 2 and 3 to initiate appropriate action against petitioner number 2, who was major in accordance with law. Honorable Allahabad High Court quashed the FIR in Salamat Ansari and others versus State of UP and others. Manu UP 2029 of 2020. On the ground that no offences were made out as two grown-up individuals were living together for over a year of their own free will and choice. See, after the striking down of Section 497 in Joseph Shine versus Union of India, a controversy has arisen with regard to whether a married person can stay with another person in live-in relationship while the marriage is surviving. So in this regard, there are conflicting views. Several courts have repeatedly refused to grant protection to such live-in couples, citing reasons that a live-in relationship between a married and unmarried person is illegal. The Honorable Allahabad High Court had refused to provide protection to petitioners in similar circumstances in case titled Anita and another versus State of UP and others, bearing writ number C number 14443 of 2021, which was decided on 29th July 2021. But a contrary view has been taken by Honorable Punjab and Haryana High Court in case titled Paramjit Kaur and another versus State of Punjab and others. The number is CRWP number 7874 of 2021, wherein protection was sought by a man without divorce from his wife. It was observed by the Honorable High Court that prima facie, at least at this stage, no offense would seem to have been committed by the petitioners who were adults in a live-in relationship with each other, even if the divorce petition was pending before the court. But this is it is not thus clear that the law is yet to, because the law is yet to be settled on this point. We'll talk about the settled legal position, which was, of course, prior to the coming of Joseph Shine's case. Now, what is relationship in the nature of marriage? There is no law pertaining to live-in relationship, but the Indian judiciary has developed jurisprudence over the years through series of judgments. In Badri Prasad versus Deputy Director of Consolidation and others, 1978, AIR 1557, it was held that a strong presumption arises in favor of wedlock where the partners have lived together for a long spell as husband and wife. Although the presumption is rebuttable, a heavy burden lies on him who seeks to deprive the relationship of legal origin. There is another case. I'll just give you the citation. That is Indra Sarma versus the VK Sarma. Some guidelines are called out, and this is a very important case. The citation is 2013, volume 15, SCC 755. Here, guidelines have been issued for testing under what circumstances a live-in relationship falls within the expression relationship in the nature of marriage. The guidelines are, of course, not exhaustive. It is said in that judgment itself, but it will definitely give some insight to such relationships. So the first primary thing that we have to see is duration of period of relationship. Section 2F of the DV Act has used the expression at any point of time, which means a reasonable period of time to maintain and continue a relationship. And this may vary from case to case, depending upon the fact situation. Then domestic arrangements, entrusting the responsibility, especially on the woman, to run the home, to do household activities like cleaning, cooking, maintaining, or upkeeping the house, etc. So this is an indication of a relationship in the nature of marriage. Then sexual relations. Marriage-like relationship refers to sexual relationship, not just for pleasure, but for emotional and intimate relationship for procreation of children, so as to give emotional support, companionship, and also material affection, caring, etc. to the other spouse, the other partner, sorry. Then having children is a strong indication of a relationship in the nature of marriage. The parties therefore intend to have a long-standing relationship. Then sharing the responsibility for bringing up and supporting them is also a strong indication. Then socialization in public. This is another important aspect. Holding out to the public and socializing with friends, relatives and others as if they are husband and wife is a strong circumstance to hold the relationship in the nature of marriage. Then intention and conduct of the parties. What is it? Common intention of the parties as to what their relationship is to be and to involve, and as to their respective roles and responsibilities, primarily determine the nature of that relationship. Intention may be expressed or implied, and what is relevant is their intention as to matters that are characteristic of a marriage. Then shared household. This expression has been defined in section 2S of the DV Act, and therefore it does not need any elaboration. Then pooling of resources and financial arrangements. If the partners are supporting each other or any of them financially sharing bank accounts, acquiring immovable properties in joint names or in the name of the woman, long-term investments are being made in business or shares in separate and joint names. So that indicates that the parties intend to have a long-term relationship. So these factors can be, these points can be a guiding factor. There's another case, Madan Mohan Singh versus Rajnikant, 2010, Volume 9, SCC 209, wherein Honorable Supreme Court has held that live-in relationship, if continued for a reasonably long period of time, cannot be termed as a walk-in and walk-out relationship, and that there should be a presumption of marriage between the parties living in such live-in relationship. By such approach of the court, it can be concluded that the court is in favor of creating a long-term living relationship as a marriage rather than giving or making it a new concept. Now, what happens to the children and women of live-in relationship? Wife wife in a narrower interpretation is a woman who is a legally wedded wife of a man. But judiciary in the recent times has developed a broader interpretation of the term wife, which includes even those women who are living with a man but are not legally married to him. Now, the idea of expanding the interpretation of the term wife is to safeguard the interest of all women who are living in a live-in relationship and prevent the misuse of the law by partners in such relationship. Now, the question arises whether a woman under live-in relationship is entitled to receive maintenance from her live-in partner or not. So the answer would be yes. A woman in a live-in relationship is entitled to receive maintenance under Section 125 CRPC from her partner. But every live-in relationship is not considered as akin to marriage. I'll again repeat, not every live-in relationship is considered as akin to marriage. There are certain parameters which need to be fulfilled. These parameters have been discussed in case titled D. Veluswamy versus D. Pathayamal, AIR 2011, Supreme Court 479. The Honorable Apex Court has pointed out that the couple must hold themselves out to society as being akin to spouses. They must be of legal age to marry. They must be otherwise qualified to enter into a legal marriage, including being unmarried. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. So here we see that conditions of Section 5 Hindu Marriage Act must be fulfilled. In another case, D. Veluswamy was, in the same case, the Honorable Apex Court also observed that couples spending weekends together or a one-night stand would not amount to be considered a relationship in marriage. So it has to be a long-term relationship with the intention of the partners to live together. And that can be gathered from the circumstances. Indira Sarma versus VKV Sarma, 2013-15, SCC 755. Here, the Honorable Apex Court also observed that the fact that twin children were born out of such a relationship, that itself showed the intention of the parties to have a marriage-like relationship. And it also showed the intention of the woman to treat this relationship as a long-term living relationship. Therefore, she was held entitled to maintenance. Now, what are the property rights of children of live-ins? The first time when the Supreme Court held the legitimacy of children born out of live-in relationships was in SPS Balasubramaniam versus Surutayan AIR 1994 Supreme Court 133. Here it was stated that if a man and woman are living under the same roof and cohabiting for some years, there will be a presumption under Section 114 of the Evidence Act that they live as husband and wife, and the children born to them will not be illegitimate. In another case, PEK Kalyani Amma and others versus K. Devi and others. That's AIR 1996 Supreme Court 1963. The Honorable Apex Court held that Section 16 of the Hindu Marriage Act. Here, the constitutional validity of the section was challenged. So it held that this is not ultra vires of the Constitution of India. It is by a rule of fictio juris that the legislature has provided that children, though illegitimate, shall nevertheless be treated as legitimate, notwithstanding that the marriage was void or voidable. So in view of the legal fiction contained in Section 16, the illegitimate children, for all practical purposes, including succession to the properties of their parents, have to be treated as legitimate. They cannot, however, succeed to the properties of any other relation on the basis of this rule. There's another case, Bharata Mata versus R. Vijaya Ranganathan, 2010, Supreme Court 2685. Where it was observed that a child born of void or voidable marriage is not entitled to claim inheritance in ancestral proprietary property, but is entitled only to claim share in self-acquired properties, if any, of the parents. So the legal position is clear. Section 16 would come into play whenever the rights of a child born out of a live-in relationship is concerned. Now, Revan's Sadyappa versus Mallikarjun, 2011, volume 11, SCC, page 1, also discusses about section 16. And it says, one thing must be made clear, that benefit given under the amended section 16 is available only in cases where there is a marriage, but such marriage is void or voidable in view of the provisions of the Act. So by interpretation, this provision has been made applicable to marriage, relationship in the nature of marriage as well. Now in Rameshwari Devi versus State of Bihar and others, AIR 2000, Supreme Court 735. There was a dispute with regard to benefits under the benefits of a government employee. The court held that under section 16 of the Act, children of void marriages are legitimate as the employee, a Hindu, had died intestate. The children of the deceased employee who were born out of a void marriage were entitled to share in the family pension, death cum retirement benefits, and gratuity. So there's another case, Tulsa versus Durgatia, AIR 2008, Supreme Court 1193, wherein it was held that a child born out of a live-in relationship. I'm sorry, the phone is ringing here because I had to come to my room. The other speakers are in the other room. I was on Tulsa versus Durgyata, AIR 2008, Supreme Court 1193, where it was held that a child born out of a live-in relationship will no longer be considered an illegitimate child in the eyes of law. The important precondition for the same should be that the parents must have lived under one roof and cohabited for a significantly long time for the society to recognize the couple as husband and wife. And it should not be merely a walk-in and walk-out relationship. In the landmark case of Champaben versus State of Gujarat, SCA oblique 11087 oblique 2011, which was decided on June 16, 2012, the respondent and petitioner started to live in. The facts of the case are that the respondent and petitioner, they started to live in a live-in relationship after the respondent promised to marry the petitioner. After some time, they had a baby, which the respondent refused to take care of. Here, the petitioner sought maintenance of a child under Section 125 CRPC. So it was opined by the Honorable Gujarat High Court that a broad and expansive interpretation should be given to the term wife to include even those cases where a man and woman have been living together as husband and wife for a reasonably long period of time, and strict proof of marriage should not be a precondition of maintenance under Section 125. I think we are running short of time. But a woman living in live-in relationship with a man is entitled to receive maintenance from a partner. And also, if a couple gives birth to a child during this kind of relationship, it will be presumed that the couple was married. Other conditions being satisfied, that Section 5, the conditions laid down in Section 5, the child would be considered to be a legitimate child. The precondition, I'll repeat, the precondition to this kind of relationship should be that both the partners living in a relationship with one another shall not be legally married to some other person. This is very important. So we'll end here so that you have enough time to take a little rest, and we'll get back again at 3:15. 3:15. Thank you so much.